in the United States District Court, Northern District of Texas, Fort Worth Division, filed January 8, 2015, not signed by the clerk that stamped it. Michael Ryan versus Halcyon Clinic, memorandum, order, and opinion. This is a published opinion. Came on to be considered the above captioned action, where Michael J. Ryan is plaintiff and defendant is Halcyon Clinic. Attached to the complaint is a large stack of documents, which includes copies of correspondence between plaintiff and others, copies of pages from various books, and a number of pages with handwriting on them. Having now considered the complaint and its attachments, the court concludes that the action should be dismissed. Part 1, the procedural background. Plaintiff, appearing pro se, initiated this action by the filing of a form complaint on December 31, 2014. The complaint itself includes few facts and does not clearly state any claim or cause of action. Take note of that. It does not clearly state this. However, from a review of the complaint and its statement, it appears the plaintiff, this is one of the things that they need proof of. I think a federal judge's published opinion would work. It appears the plaintiff has a serious brain injury. He got that from the records. And he has previously hired counsel to sue the defendant in California, but problems have arisen regarding his attorney's in and the status of the California action. In the complaint, plaintiff also requested an emergency hearing, which the court construed as a request for a temporary restraining order. Another judge of this court denied the request on December 31st, 2014. In considering the request for temporary restraining order, the court noted plaintiff's filings in the instant action appear to mirror those he filed on December 22, 2014 in civil action case number 3:14CV4493B in the Dallas division of this court. That action named the defendant and appears to concern the same subject matter. Note, it did not, because it was just versus House, and I was told I could amend to add 6 different defendants, so it was not only going to be House. The action named same defendant appears to concern the same, so that's incorrect. In denying the request for injunctive relief, the court found not only that the plaintiff failed to allege a discernible claim, but under the first to file rule, the court was without authority to act on this later filed action. Now, the first to file rule is going to be rendered moot, so that's going to be out. This court was without authority to act on this later matter, so the court is with authority because the magistrate judge never had authority. So at this time, especially, C, order signed December 31st, citing Berger. Analysis. The first to file rule. The so-called first to file rule requires the principle of comity that requires federal district courts to exercise care to avoid interference with each other's affairs. And it gives a cite that to avoid waste of duplication, to avoid rulings that may trench upon the authority of the sister courts, and to avoid piecemeal resolution of issues that call for a uniform result. A district court has discretion to dismiss or transfer an action where the issues presented can be resolved in an earlier filed action pending in another district court. Under the first to file rule, the court which the case last filed must refuse to hear if the issues raised the case substantially overlap. Well, mine was to be an oral deal. The whole thing was supposed to have a hearing because of disability. I was told that I would. The instant action represents what is at least plaintiff's second federal action against this defendant. The same party is named the defendant here as in case 3:14 CV 4493B BH. Now, these numbers are not going to match, you'll find. Although the court cannot readily discern the claims, okay, that's huge. The court cannot readily discern the claims. It was written in handwriting by a person with brain damage. The cause of action, and the cause of action is attempting to assert. It's looking like some inability to file. Complaint, the general issues presented plaintiff's traumatic brain injury. It's coming from a federal judge from reviewing the evidence and putting it in a published opinion. That's final. His litigation in California, his apparent frustration with his attorney's court that is state the same case number in 3:CV 4493B. Thus, there can be no question the parties and the issues between the two cases substantially overlap if they are not identical. Like I said, I was going to write down all the defendants, but they told me to do it when I came back, and the court case was gone. Because the court had found this action substantially overlaps with the first filed case, the court must decide whether to transfer or dismiss. Now, here we go. This is their primary reasoning. The United States magistrate judge to whom case number 3:CV4493B was assigned, there was absolutely no waiver, transferred it to the United States District Court for the Central District of California, Western District, which the magistrate judge determined was the proper venue. I'm wondering how, on an ex parte, to avoid travesty of justice under ADA and corruption and all of that. Hence, plaintiff's claims against the defendant are now in the hands of a California for determination. While the court could likewise transfer this action to the Central District of California, the court can see nothing to be gained by doing so. Accordingly, the court is exercising its discretion to dismiss the action. I'm going to say that the judge says something in here, and again, I've said, like, doctors don't usually tell people that they were called by another surgeon. And he says something in here that, to me, is a compliment to me, and a just tiny one by a federal judge, and something like that could almost be construed as a personal comment is rare. Plaintiff's request for emergency hearing. Late in the day on January 7, 2015, plaintiff filed another request for emergency hearing. To the extent plaintiff is again seeking a temporary restraining order, he is required to show. Now, this shows how easy it could be for me to do, but that this stuff is difficult. Number one, a substantial likelihood of success on the merits. Done. That they face substantial threat of irreparable harm. Well, you've seen it all happen. The threatened injury faced by plaintiff outweighs the threatened harm to defendant. Okay. Granting the injunctive relief will not disturb public interest. Okay, so it's a win. The court finds plaintiff has failed to make the required showing, as the court is unable to clearly discern the claims and causes of action that the plaintiff is trying to assert. Well, I shouldn't be my own lawyer anyway. They made me do it in California, even though it's against California law. Plaintiff has not shown the likelihood of success on the merits, nor plaintiff clearly explained the relief he is seeking. In other words, having trouble trying to put on paper, as opposed to orally, what it is that I'm trying to do. Nor plaintiff clearly explained the relief he's seeking from the court were he to prevail. The extent plaintiff is asking the court to intervene in or take action pertaining to any court or party located in California, the court is without authority to do so. Additionally, as explained in the December 31, 2014 order, plaintiff has already filed the action against the defendant concerning the same subject matter, as there's no disservice to the public interest by denying injunctive relief. And although plaintiff indicated in his latest filing that he intends to name as defendant a Pennsylvania attorney, thus creating diversity, it is not all clear, doesn't mean that it's not, that the court would have personal jurisdiction over such a party, or if anything in the complaint could be construed to state a claim for relief against the individual. To the extent plaintiff is merely seeking a hearing before this court to discuss the action, the court is declining. This is what I mean is, I could be wrong. It just seems like a throwing me a bone. While this court is not unsympathetic to the plaintiff's situation from a legal perspective, the court is unable to afford any relief. I think the judge did what he had to do, but I think, in essence, reading through with legal experience, the judge is saying that this plaintiff is disabled. He can't file right. We can't tell what he's trying to say. But he says from his own personal legal perspective, he's not unsympathetic to the situation. That's as close to saying he would win. And the magistrate judge thing takes out the first file rule and the magistrate judge. And so you'd be able to have the hearing. Because even though he couldn't discern it, the whole thing was whether or not we could have the hearing. And if I got in front of a judge, that's the whole point. So that's another case that could be brought up immediately if I had a car or a phone or contact or wasn't hated. So that's one of many, and that's in the same court as Vanessa filed. Now, I went to Fort Worth one time to get a printout of that case when I had money, and they said they didn't have it. They didn't have it in there. I've got that too, where it says the search doesn't have any results. And I went there the other day when I rented a car, and they wouldn't give me a copy because I didn't have a money order. I'm like, well, God, here's a copy of this forgery and fraud, and I can't even get a copy.